So just a very brief overview for those who don't know. Section 230 of the Communication Decency Act provides immunity provisions for online content providers. So a Facebook or a Twitter or a Google cannot be held liable under 230 for user-generated content. For those, it will, under the words of the law, I'm going to use the term platform. I know some people disagree with that, but just for ease of use, platforms won't be held liable as the publisher or speaker of user-generated content, and also won't be held liable for the moderation decisions they make. It was really, it was a bill in the 90s that came out of something called the Communications Decency Act, and it sort of, I think it brings it all full circle that we're talking about sort of sex work and sort of the erotica that we are, because it really came out of an anti-pornography bill called the Communications Decency Act. That anti-pornography bill was later struck down by the Supreme Court in a case called Reno versus ACLU. But Section 230 and its immunity provisions remain, and it really was a way for Congress to give guidance to these online service providers that were hosting user content to avoid this moderator's dilemma problem that came about by a result of a couple key cases involving CompuServe and Prodigy in the early part of the internet, where on one hand, in a CompuServe case, the CompuServe wasn't seen as the publisher of certain material. It was seen as a sort of a passive distributor, so not liable for user content. And in another case, in this Prodigy Stratton Oak case, they were seen as exercising some editorial control, and got to the point where if you did anything to manage user-generated content, then the platform could potentially be held liable for torts that came out of that. I don't want to talk too much. Is there any parts of the history that you all are particularly interested in or want to get into?
Well, maybe I'll just jump in really quickly and say, I think the duality of what was going on in Section 230 is a really interesting one. So it's right at the dawn of the internet, right? And on the one hand, you know, it's sort of Congress having this one moment of saying, here's this thing coming down the pike, and we're not sure exactly what it's going to look like. Here's our thoughts about what it could be. It's important to remember it's coming off of the AT&T breakup, right? Like the dominant communications system up to this point is a phone system, and AT&T kind of controls everything. And then suddenly the internet is poised and it's architected to avoid all of that centralized control. And so I think what you see at the kind of the beginning of Section 230, in addition to all the mechanics you mentioned, you see these findings and these policy statements where Congress sort of says, look, the internet has the potential to, you know, open up all of this control for its users over the sorts of content that they see and over the kinds of services that they get to access. And then on the other hand, it's sort of hitched in this awkward way to this anti-pornography bill, and it says, we think all these new services that are going to come out and going to use the internet are going to play a key role in making sure that people, you know, don't get access to objectionable content. And we want to make sure that they have the clarity that they need to go in and sort of block the kind of objectionable content that we are worried about. So there's this dual kind of frame of like, we want to empower users to see what they want, but we also want to empower platforms to keep content off of their platforms that we might not want to see. And so that's kind of this complicated early genesis, I think, of both 230 and the CDA more broadly.
Thanks, Blake. And one thing that I was interested in doing a little preparation work on this and reading some of the stuff that you've written on here is typically as sort of a litigator, I look at the operative parts of the statute, right? I look at the immunity provisions and see, you know, here's something that I could use to say if I was representing a platform, I could use this as an affirmative defense, say we can't be held liable for this user content. What I actually didn't know is that the FCC in the early days was sort of using some of those preliminary findings about how these platforms were developed in a sort of hands-off regulatory context to develop sort of a diversity of viewpoints. Can you talk just a little bit about how that worked?
Yeah, and I don't want to dwell too long on like telecom history because I know it will be interesting for me and not for everyone. But I'll just say, you know, we say that 230 is in the Communications Decency Act. It's actually part of the Communications Act, which is the statute the FCC administers, and it's one of the only parts of the Communications Act when it was updated in 1996 that had any reference to the internet. Right. So the FCC is charged with administering the how our telecom networks work, and suddenly they have this profound new telecom network, the internet, and they have almost no guidance about what to do with it. They've got to do almost entirely reasoning by analogy, and they've got this one section 230 that actually says a bunch of stuff about the actual internet as opposed to giving a lot of kind of imprecise analogies. And so 230 became this kind of backdrop of like all of this really interesting stuff that the FCC did in the late 1990s and early 2000s as it was trying to spur competition in the internet. So, you know, you used to be able to actually go out and choose where you were going to get your dial-up service from. You might have had like several providers that you could choose among. The FCC was doing lots of policy to try to ensure that sort of thing. And one of the things it pointed to undergird that policy is it says, hey, we've got Section 230 out here. And Section 230 says, we don't want to regulate what's happening on the internet in terms of the platforms and the services and, you know, the kind of applications that are going to be developed. And in order to do that, we both need to take a hands-off approach as the FCC up there, but we also need to make sure that there's a lot of competition happening down at the network layer. And so the FCC used Section 230 as kind of a backstop for all of the stuff it wanted to do to kind of inform, like, here's how we're going to approach internet policy, given that the rest of their statute said almost nothing about it.
And it's interesting that those findings and policy portions of Section 230 are now being sort of leveraged into some of the new proposals in how to change it. I feel like, and some folks are doing it in good faith, I feel like, and some of them are sort of have a political bent to it. But the gist of it seems to be, why don't we give some teeth to these portions of the statute?
Yeah, I think that's fair, and I know we'll come back to the reform proposals at the tail end. So maybe I'll reserve comment till we get back to it.
Great. And then so as the courts start applying Section 230. There are a couple cases that start to come out that really show how broad its application can be. So a case that people talk about a lot is the Ken Zarin versus AOL case, where there was an online posting for really offensive T-shirts talking about the Oklahoma City bombings for sale and saying, call this guy Ken Zarin to buy one of these, and also a radio station that promoted that. And then when Ken Zarin sued AOL because he asked them to take it down, told him it wasn't him, the court found that AOL couldn't be held liable for that user content. And a lot of people point to that decision as something that expresses sort of the breadth of it. But even as we go forward, and it's interesting to me because, and I'm going to post something into the chat, because Cox, who was one of the authors of the bill, I don't know if you all read this, but he had sort of an op-ed just a couple days ago called, Policing the Internet, a Bad Idea in 1996 and Today. There were some really striking things that I didn't know about it. Or, you know, maybe they're in Jeff Kosif's book and I just forgot them. But one of the things was when it passed, I think 25% of senators had an email account, and maybe half of the House had access to the internet just generally. So it really shows that sort of the folks that passed it, the Congress that passed it, wasn't really familiar with the internet and the workings and all the things that would come about. So these cases start to come down, and then there gets to be this political will to change 230. So there's a case, Daniel versus Arms List, about a gun transaction where survivors of a shooting sue this basically a platform for the exchange of firearms, saying that they should be held liable for the sale of that to somebody who shouldn't have had guns. There's also a Herrick versus Grinder in the Second Circuit, where there are claims that there's basically a products liability cause of action saying this platform was designed to cause harm to certain people and actually did cause harm. And also the Backpage cases that we'll get into in terms of the FOSTA-SESTA effect. So I feel like courts were starting to really broadly apply Section 230 and in ways that people didn't necessarily like, and led to this will towards reforming it or little carve out sections of it. I don't know whether Kendra or Blunt want to weigh in on sort of FOSTA and SESTA and what its effects were and what we can learn from that. But please.
Sure, I can sort of maybe take a first crack at doing like an overview and sort of bridging between what Andy was talking about with Backpage and sort of what happened with FOSTA-SESTA. So, you know, as Andy flagged, there were sort of a bunch of cases that explored what I guess we might call the edges of 230. And one of them was Doe v. Backpage, which was a First Circuit case, basically finding that Backpage, which was a classified ad site that hosted a lot of ads for sort of all kinds of things, but often including sex work, had a person who had been trafficked in ads for their services, I don't quite know how to say that correctly, had been placed on Backpage, sued Backpage saying like, you are liable, you don't have a 230 defense. 230 was never meant to protect this. And the First Circuit said, well, actually, you know, there's no reason to think 230 wasn't meant to cover this. We don't like this outcome, but this, you know, 230 protection applies, the case is dismissed. And sort of that moment, that case kind of laid the groundwork for FOSTA-SESTA in terms of sort of creating, I think, political will to amend 230 to sort of specifically in the same way that kind of amusingly we see that like back in like sort of Cuppy and CompuServe, you know, that Congress comes in and says, hey, no, it's supposed to be the opposite. They basically do the same thing with Backpage with FOSTA and SESTA, except they do more than that. So, you know, the reason we talk about FOSTA and SESTA is there were originally two bills, which contained various different elements of the actual bill that came to pass. But what FOSTA does is a bunch of different stuff. So the first thing, and often I think the thing that gets left out of conversations around 230 that's most important to talk about FOSTA doing is it creates a separate federal criminal claim for operating an online computing service that's used to basically that people use to that promotes or facilitates either prostitution or sex trafficking. Now, the law distinguishes between these two things, talks about sex trafficking, which has to do with either minors, anybody under the age of 18, or folks who are engaged in sex work because of force, fraud, or coercion, also called FFC. You know, the reality is, as many survivors, sex workers and survivors of sex trafficking talked about, is that like life is more complicated than that, right? Like that you know, both that sex work can be engaged with because that's the best way folks can make a living, but also that, you know, sex trafficking is a sort of complicated state that's not really summarized well by, you know, sort of this, our mental image of, you know, sort of innocent women, white women taken off the, innocent white girls taken off the streets of wherever they're from, and you know, sold into sex slavery, which is sort of the classic, some of the classic framing. Anyway, I'm not to get too far off topic. FOSTA-SESTA, right? So first of all, creates a federal criminal claim. Federal criminal law has always been exempt from Section 230. Down there, we talked about A, B, and C. Well, E of Section 230 says, you know, this does not immunize you from liability for federal criminal law, but Section 230 does immunize service providers from state criminal law. So FOSTA also creates a number of 230 carve-outs. One to deal with Doe v. Backpage for civil claims based on Section 1595, which is basically the Trafficking Victims Protection Act. It's a federal civil claim for sex trafficking, but it also creates state-level criminal liability for state criminal laws that have the same elements as the federal anti-trafficking statute, which is Section 1591. That's a little tricky because it's actually unclear that whether there are a lot of state criminal laws that qualify, just because the way the law is written, and I think it's not really, I don't think it's controversial to say it's a really badly written law. Like, just independent of whether you think the outcome is good, and it definitely isn't, but even if you did think that, the law is like just very badly written and it's hard to follow. So it's actually unclear how much of like effects it would have on service providers' liability, because the way the 230 carve-outs are written is quite narrow in some respects, but could also be quite broad in others. But just because the law, the FOSTA-SESTA, the version that passed, was actually like quite sort of, could be read as quite narrow in its 230 carve-outs, doesn't mean that like the reaction sort of by internet platforms wasn't disproportionate. And I'll let Blunt talk about that.
Sure, and I sort of just want to begin by placing myself within this conversation. So I was one of the co-founders of Hacking Hustling, which formulated around 2018 after the removal of Backpage and the subsequent signing of FOSTA-SESTA into law. And so we're a collective of sex workers and accomplices working to interrupt state surveillance and violence that's facilitated by technology. And we believe that sex work is work and that all work is vulnerable to exploitation under capitalism, which I think sort of will help us later on in the conversation understand the overly broad interpretation and application of this law. And so I also want to say that Backpage, FOSTA-SESTA was not necessary to take down Backpage, even though that the writers of the law say like champion the removal of Backpage as a win. Backpage was actually taken down like 4 days before FOSTA-SESTA was actually signed into law. So it was a law that was totally unnecessary to remove Backpage from the internet. I wanna say that sex workers and access to online spaces is a harm reduction working tool that sex workers use to stay safe, to share information, to share bad date lists of violent clients, and that sex work, the stigma associated with sex work can create an incredibly isolating experience, which also contributes to that harm, and online spaces foster community that actually keep people safer. So FOSTA-SESTA and the removal of Backpage isn't anything that's new. We've been seeing websites that we use to work on be taken down before FOSTA-SESTA was ever proposed, since we started using these websites. Sex workers are some of the earliest adopters of the internet, of personal websites, of payment processors, and as soon as those companies start turning a profit or get funding, we're the first people to be removed, before Nazis. So this isn't anything that is new. It's just a continuation of this horrorphobic online landscape that we have to work in, organize, and take care of each other. So working online provides us with more time and space to negotiate with clients. It helps us connect with community, which keeps each other safe so we can share information. And while a lot of the violence that sex workers face is at the hands of the police, working online actually creates more distance between our work and police violence. There's this really interesting statistic that was studying Craigslist erotic services opened in different states at different times. This is some of Scott Cunningham's research, and his statistic that I find so interesting is that after Craigslist erotic services opened, we saw a 17% reduction in all female homicide in the following years. And that's not just specific to sex workers, that is for all women. And I would argue that that number is underreported. And it's because when you need access to income, Craigslist erotic services allowed you a quick and like low fee barrier way to accessing resources. And so when we think about what makes someone vulnerable to trafficking, it's lack of access to resources, being disconnected from your community. And when we think about the effect that FOSTA-SESTA has had on the sex working community and folks who are experiencing labor exploitation in the sex industry, what FOSTA-SESTA has actually done is push people into situations and circumstances that actually make them more vulnerable to exploitative labor conditions. I can pause there. I can keep going. I can pause there.
Can I just add something real fast to what you already said? So just in case folks are unfamiliar, as Blunt was saying, right, like Craigslist erotic services ads shut down after FOSTA, like just sort of wholesale the day after it passed. Craigslist was like, nope, we're not running this anymore. And, Hacking, Hustling, and Survivors Against SESTA, sort of a sister organization, has been keeping like sort of a running list of all of the sort of service providers that either shut down classified ads or just shut down entirely. And I think like last time I checked, it was like, 30, 40, 50, like sort of sites. So it's, so they may have gotten Backpage without a FOSTA-SESTA, but many of the shutdowns afterwards that Glenn is talking about that dramatically affected like sex working communities, like it's sort of directly tied to fears about liability, whether those fears are realistic or not, tied to FOSTA-SESTA.
Right, and so what we saw with the free and the niche sites, the smaller sites that don't have the money to pay for legal counsel, we just saw websites shuttering, and it's just like one after the other. We lost websites and because of the like vague language within the law, we don't know if sharing harm reduction information will be criminalized under this law. So we lost a lot of like bad date lists. People didn't know if sharing information with community members would put themselves at risk. There was a lot of people didn't really understand the impact of this law, because up until last Thursday, when City X5, Kendra, you can talk a little bit more about that, but FOSTA, City X5 is the first case that FOSTA is being used in. But even without it ever going to court, we saw, and I think it's more than 30, I think it's like in the hundreds of websites and spaces that we've lost access to. Reddit also like preemptively took down a bunch of their subreddits before it was signed into law. So the chilling effect that this has had on community, as well as the self-censorship that sex workers and survivors of trafficking and folks who hold like multiple diverse identities, their speech has been significantly chilled, and that acts as another form of violence that this bill has had.
So I think that's probably a good reason why we're here speaking on this specific topic today, is because when folks talk about changing Section 230 and its protections, it's not just, will a court eventually find that somebody is liable, whether civilly or criminally, for something. It's how will these platforms act in other sort of extra legal, extrajudicial ways to affirmatively censor items, and how can we sort of map that on, not to decenter it from the sex work talk, but how can we map that on to other problems people are trying to solve, right? So if one thing we're concerned about is, political viewpoints, or even access to firearms, or any of these things that people say are these really, laudable goals and horrible things that we all think we should be stopping, how is that affected? How does that affect, or even make worse the things that we're not trying to touch?
And Andy, before we move on to that, I wondered if I could ask Kendra a quick question, because I want to think about how the broader politics that led to FOSTA and SESTA and led out of FOSTA-SESTA affected some of the debates that we're getting in now. Kendra, you alluded really briefly at the beginning of your remarks to some of the politics around how FOSTA and SESTA got passed and how that battle worked out. Can you talk a little bit more about like who the players were in that fight, and how that, at least like superficially, how that battle was presented in the press?
Sure. So I think that, FOSTA was very much framed as a bill to prevent sex trafficking. Actually, on the last 230 panel I was on, somebody asked me what FOSTA stood for, and I was like, I don't know. That is so beyond the space in which I engage with this law. But both FOSTA and SESTA were very specifically presented to prevent sex trafficking, and that's how they were marketed in Congress. I think folks often talk about sex work is getting caught up as an unintended consequence, and that's not true. The bills are not confusing as to how they talk about sex work and sex trafficking. They clearly talk about both. So I think, first of all, it was sort of a marketing. I think that the folks who created and drafted these bills understand that sex trafficking and sex work and what prostitution is the language the bill uses are different things, and specifically targeted both of them. That may be because the folks that drafted these bills believe that all prostitution is the same as sex trafficking, or sort of they find it politically useful to not meaningfully distinguish, but I think it's really important just to say that it's not an accident that sex workers were really harmed by this bill. It's like a direct intended consequence. The sort of, Blunt, do you want to hop in there?
Oh, I can wait until you're done with what you were saying.
Okay. But Blake, to address your question more directly. So, you know, there was widespread bipartisan consensus on FOSTA. Like, this isn't like just sort of one side or the other, you know, being bad on this issue. But, you know, one of the things that happened was there was sort of initially companies like IBM, Oracle, and I think I'm forgetting one more, large tech companies, 21st Century Fox, not a large tech company, but large companies that are sort of not, that may have like a tech presence, but aren't sort of really deeply invested in 230. Like, they don't necessarily need the 230 immunity to maintain that tech presence. We're the first to come out in favor of FOSTA-SESTA. You know, IBM in particular sort of denounced, you know, Google and Facebook and all of these online, other online platforms for sort of not being in favor of FOSTA. And that, along with sort of lawmakers, put pretty intense pressure on the sort of traditional tech platforms that have been more pro 230 in the past, such that actually the Internet Association came out in favor of FOSTA-SESTA. I think two things to flag there, and then I'll let sort of, I can let sort of Blunt respond as well. One thing is, you know, I think that the sort of mechanics of how that went down in terms of the bill passage are like very complicated. But I think there was this idea that, well, you know, we can create this new federal criminal provision and that's going to be fine because like we're, as these large online platforms, not going to be targeted by this federal criminal provision. Like, we trust federal law enforcement not to target us. I think that really threw sex workers under the bus, especially sex workers who are already criminalized, and small sites, both small harm reduction sites that were like running bad date lists, but also like sort of smaller sites that might have sex worker content. The example I'm thinking of in particular is I worked with a site that produced content that was like aimed at trans folks, and there's a lot of trans folks who are sex workers. And they were really upset actually because they had to basically write into their content moderation rules about engaging in sort of conversations around sex work on their platform because of FOSTA. And this is a platform that wanted to be pro-sex work, but because of their concerns about FOSTA liability couldn't be. So that's point one. So I think that many of the online platforms saw this as an opportunity, like saw that didn't want to sort of be anti-this, be seen as being pro-sex trafficking. I think, well, actually, I'll stop there and let Blunt talk.
Yeah, I think that's a really, like, that was a great question to get more clarity on, because I think lawmakers know that they can pass bipartisan legislation under the language of ending human trafficking or stopping child sexual exploitative material that actually erodes at all of our rights and disproportionately targets the marginalized communities that they're purporting to protect. So as we look at upcoming like 230 carve-outs, we should look at the language that's being used and the communities that are sort of being like thrown under the bus in order to do that. And I also want to challenge the use of the language unintended consequences and collateral damage, because these aren't the unintended consequences. Lawmakers knew exactly what the impact would be on sex workers because we told them, like we were on the Hill telling them how this law would impact us. And some of the research that Hacking Hustling does has confirmed that what sex workers warned lawmakers would happen when FOSTA-SESTA was signed into law was exactly what happened. And yeah, I'll stop there for now.
I did try to catch myself when I mentioned unintended consequences earlier.
Yeah, can I pick up there? So, I mean, I think there's, and maybe I could take this and transition us into the broader conversation about the reform proposals. So I see there's kind of three layers of the politics here. And Kendra, this is just a different gloss on what you said. But one is the advertised purpose of this legislation is we are going after sex trafficking, and we're very sorry for the unintended consequences that we might cause. It was an accident, right? The level two of the politics is actually those unintended consequences were quite intended. And there's this puritanical, Blunt, I think you said horphobic, attempt to go after sex work, and there's probably a constituency of folks going after that. And then level 3 is like folks who don't really care about the sex trafficking or sex work issues at all, but are opportunistically pushing this legislation to go in a different direction. And I want to pick up there because I think that's actually like highlights how cynical this legislation is and how terrible the impacts on sex workers are. Is they're basically, it's basically an opportunistic use of this legislation to push a broader set of priorities that don't have anything to do with it. So you mentioned there are some companies like IBM and I think maybe Microsoft and maybe some of the other Internet Association oriented companies that were sort of like, hey, we don't have 230 problems because we don't really run online platforms. So this is a good chance for us to just like pile onto our rivals, right? Like we're just gonna like throw shade at them, right? And like get the government to go after my competitors for things that they do that we don't. Perfect. I think another quarter, so you mentioned 21st Century Fox, and I think you could broadly round this out to include Disney and some other groups. They've been fighting a copyright battle against the Googles of the world, the YouTubes of the world for the last 15 or so years under another provision called Section 512 of the Digital Millennium Copyright Act, which is kind of the intellectual property companion to Section 230. And they have wanted to impose responsibility on Google and YouTube beyond what Section 512 allows for. And they basically lost that battle for the better part of 15 years. And they saw, I think, with FOSTA and SESTA, an opportunity to say, hey, if we can't get Congress to go our way on copyright, we can use sex trafficking as a thin end of a much broader wedge to open up broader conversations around the liability for platforms. And then I think the last group that's important to mention in here is internet service providers and telecom companies who have been under the thumb of the FCC for a long time. So sorry, I had to pivot us back to telecom law, but they've been under the thumb of the FCC for a long time. We've had this battle about net neutrality, which is internet service providers are the problem, right? They are going to discriminate against people's content, discriminate against people's applications. They're going to control what people get to see on the internet. And that's a real problem that the FCC needs to deal with. So the ISPs and their lobbyists had to develop a counter narrative to that. And the counter narrative was like, actually the problems that you should be concerned about are happening on these platforms up here, right? It's not us, right? We just want to like give people, access to, Spotify for free, right? Like we want to like zero rate data. Like we want to do things that are good for consumers. And it's all this stuff that's happening up here that's bad. And by the way, nothing could be worse than sex trafficking, right? Like let's latch onto that because that's a good way to shift attention up there. And so I think those kind of led into FOSTA and SESTA. And then they also start leading out of FOSTA and SESTA because they say, you know what, actually part of that narrative is it's not just the back pages. It's not just sex trafficking websites. And, by the way, who cares about all of the collateral damage to sex working sites and sites that support sex workers? It's Twitter, it's Facebook, it's all these big platforms. Like that's sort of the next target. And so there's a way in which FOSTA-SESTA was kind of this way station for these broader debates that get us into the reform proposals that are kind of on the table now.
And can I piggyback off of that? And Blake, yeah, I think that especially the other one I would mention in particular is Oracle. I think has been really successful at sort of like picking up on this anti-Google
out of the fight
sentiment.
with Google. Yeah.
But just to piggyback off of that and sort of raise 2 points about I think the broader ecosystem and sort of how 230 weighs in and why I think actually it's so important to spend a lot of our time talking about FOSTA before we dive into the other reform proposals. So one is, I think that, there's lots of proposals on the table about changing Section 230. I think my own personal views on them are that I both understand why there's been a lot of like legal and policy energy around 230 because it's sort of like it, in the language of lawyers, right? It preempts the field. It's big, right? But I also think that it's actually, getting rid of 230, even if we just got rid of it tomorrow, does not actually mean that a lot of the like concerns about equity that many advocates of 230 reform are bringing would be solved. You know, I have some bad news for you about like the underlying tort system if you're interested in sort of like racial and gender equality. Like, it's real bad. Like, you don't have to take my word for it. Jennifer Wingens and Martha Chamalis wrote this book called The Measure of Injury. I really highly recommend it to anyone who's like, as soon as we get rid of 230, then like we can really deal with these like cyber stalking and harassment problems, right? And I don't say that to trivialize the actual meaning of 230, right? Like, and the way it does preempt the field and change the legal landscape. But I think there is often insufficient attention paid to like how the underlying legal regimes that would be the thing that would happen if you got rid of 230 are incredibly harmful. And that's why I actually think it's so important to talk about FOSTA, because like we got rid of 230 and actually things are way worse than they were previously because of the sort of the way in which these existing legal regimes that wouldn't exist, that weren't operating prior to 230 are operating on these platforms, and all the ways in which they're whorephobic, they're transphobic, they're racist, they're sexist, right? Like all of that stuff. So I think that that really, to me suggests that, especially as we go into the sort of reform proposal stuff, it's our job as advocates who work on 230 issues to be in really robust discussion with the communities that are most affected by the kinds of legal issues that we're claiming we're going to solve by either reforming or not reforming 230. And just like 230 is like catnip for tech lawyers, right? It's like it takes up the field. It's a big thing. It's complicated. It's hard to explain. Maybe not, depending on who you listen to. And so like the fact that we like it as tech lawyers is actually probably a sign that we should like be working elsewhere. I can see I pissed off Blake enough that he's just literally covering his camera. But
no, I was just trying to bring myself back into focus, but no, I completely agree.
Yeah, so so as we move into our reform conversation about reform, I think it's just so valuable to be like, not just be like, oh, like our answer is 230 or not 230. It's like, what are the underlying legal systems and how do they harm like the folks we should be centering in these conversations?
Thanks, Kendra. And I also just wanted to share like a little anecdote about this, how FOSTA-SESTA sort of sits in this like overarching whorephobic ecosystem when it comes to organizing. While hacking, the tech industry was just about like silent other than their support for FOSTA, and it's just like incredibly frustrating to be simultaneously shadow banned on these platforms, like screaming into a void about the harms that we know would happen with this legislation. And this one story sticks out in my head is when Hacking Hustling organized a social media power hour to sort of bring awareness to FOSTA-SESTA before it was signed into law. And so while I was using like a fuck FOSTA hashtag, I was shadow banned into oblivion. My post got 0 impressions, but what they did do is that the hashtag was still visible to people who were targeting ads. And so I was getting targeted ads from the Department of Homeland Security talking about why trafficking is an issue and asking for my support of FOSTA. And so this is the ecosystem that we're working in, and also why I think it's just like hitting that point home that Kendra is saying, that like I'm super grateful to be able to be here and join this conversation, because I don't think I have to be an expert on 230 law to tell you how it impacts my life and my community's life. And especially when our voices are literally being suppressed on the platforms that we use to have these conversations, I think it's even more important to make that effort to connect with people. And another anecdote is when we were passing around information on the Earn It Act and the ways that this bill is also overly broad, and the way that it would impact communities similar to how FOSTA did. And my content was marked as explicit content when I was going to share it. So it was not only suppressed in the algorithm, but you also couldn't see what I was posting. And that was from my organization's Twitter, not like my personal sex working Twitter. And so I think that it's important to contextualize like all of these carve outs within what we're already seeing in content moderation online on these platforms.
And that's a great point. And actually, I definitely want to get back to the shadow banning and algorithmic portion of it. But before we leave this FOSTA-SESTA conversation, I do just want to touch on a little bit about decriminalization. So we've talked about if the statute as it is already carves out application of federal criminal law, and the statute being 230, and an inconsistent state criminal law, how much do you think in practical effects or even legal effects that decriminalization of sex work would change things? Would it change things at all? Is that a part of the solution, or is that just another complicating factor?
No, I think, thank you for asking that question. And thank you for saying decriminalization and not legalization. What sex workers want is decriminalization. Legalizing sex work would just keep the same folks who are already being targeted by the police in harm's way. We want the decriminalization of sex work, but I actually don't know how big of an effect it would actually have on FOSTA when the way that the law differentiates between sex work and trafficking is so vague. Like I have comrades who are locked up for the criminalization of their survival, of their self-defense, who are locked up for sitting in a car outside of their friend doing work, and that's considered trafficking. Or my mom is my safe call, which means I call her before and after every session so that someone knows that I'm safe, the address of where I am. And like under some laws, that's technically considered trafficking. And I don't know if Kendra, if you want to talk a little bit more about the legal nitty gritty of those.
Yeah, so it's kind of complicated, and I'm not going to do, I will do my best. There are folks who know way more about this than I do. Unfortunately, one of them, Laura Lively, couldn't make the panel, so I'm going to try to stand in for them a little bit. So, I think decrim will like help. The reality is help on the ground a ton. I'm not sure it's going to help as much with the kind of the difficulty with online platforms for a couple different reasons. First of all, I think it's fair to say that the actual carve-outs for 230 that are in FOSTA-SESTA are very small compared to the reaction that tech platforms had. I'm not saying that Craigslist should have just stuck it out and waited to get sued, because that's their general counsel's decision and not mine. But I do think that what we did see was that, platforms and tech platforms saw which way the wind was blowing and just shut stuff down because they thought potential 230 liability might result. Or as Blunt said, right, they were small, they couldn't afford lawyers, and they were just like, we're out, right? So I'm a little worried that no matter what happens with FOSTA-SESTA, it's gonna be hard to get that horse back in the barn or cat back in the bag or whatever metaphor you wanna use. That independent of FOSTA-SESTA or even Decrim, I think that many of these platforms just sort of were like, nope, we want nothing to do with any explicit content. And I think, some folks have attributed Tumblr's removal of explicit content to FOSTA. I'm really skeptical of that, just because I think that had to do with what Tumblr's internal sort of team wanted, and the sort of the image they wanted to promote, right? I don't think that was FOSTA related, but right, once you've removed this, sort of built all these tools for sort of deranking or banning or eliminating this kind of content, I think it's a little bit hard to sort of go back. So that's one point. With regard to decrim in particular, one of the weird things about the federal anti-trafficking statutes in the Mann Act and the Travel Act, so those are the federal laws that regulate sex work and sex trafficking, is there's no actual definition of the word prostitution in them, right? So they use the word prostitution, but prostitution is a state crime, right? Each state has its own definition of what constitutes prostitution. For example, in New York, BDSM isn't illegal sex work. That's not true in other places. So each state has its own law. Many of the what we do know about the criminal indictment that's been held under the felony charge of FOSTA, as well as the way prostitution has been interpreted more generally, is that courts often don't look to what prostitution meant in that particular state unless it's a state court and a state charge. When we look at the federal stuff, they're kind of does it feel like prostitution? And it probably is, right? They know it when they see it, to sort of use that quote in closer to its original context. And so I worry that even decrim, like local or state decrim, would make it not necessarily lead to like federal law enforcement not going after these platforms. You can think of it kind of like marijuana, although there are really significant differences in terms of the interaction between federal and state level law. It's kind of difficult for me to imagine that, you know, the Travel Act, the Mann Act, and the new 242(1)A, the new criminal provision, would sort of go away. One last thing I'll say on this before I'll stop. There is an affirmative defense to the new criminal provision that the sex or prostitution is legal in the jurisdiction. We did some looking. I think that legal in this case does include decrim, so that's good. But the other thing here is, you know, just from a realistic perspective, most of the most successful internet platforms are not just one state or one city, right? If we're talking about like big platforms, the internet's a global medium. So, you know, having platforms that have like local level, that are making law or like looking at law in local jurisdictions, which is how decrim would have to happen, it just strikes me as a little unlikely. So that's my downer news about how decrim interacts with FOSTA.
So that's probably a good segue to start talking over some of these. And I don't want to get in depth. I mean, it's probably too premature to really plumb the statutory language here, but I just sort of want to talk a little bit conceptually about what's been put out there. And certainly want to give you all a chance to talk about the Earn It Act. One thing that's striking me about some of this, and especially in reading Erased, which I put in the hacking hustling document that I put in the chat, was sort of the value of anonymity to sex workers and really to internet speakers in general. So a lot of what we've seen, and even in some, I think part of the back page lawsuit allegations were, this isn't just as it were, neutral platform for speech. You're affirmatively enabling people to act in certain ways. And one of those ways was to have anonymous accounts and to, you know, strip things of metadata to be de-identified. Is that something that we should value in an internet society going forward? I mean, can we talk about a little bit about the why we want that and how Blunt even it affects you and your community?
Sure. I think sex workers like anonymity or pseudonymity, I can't say that word. Pseudonymity.
I literally can never say that word, so I'm really reassured, Blunt, that you also had trouble saying it.
Because people stalk and murder us. So I think if you want to have a space where marginalized communities can share their experiences and reduce their risk of harm, having anonymous and pseudonymous spaces is incredibly important. And like there are so many different reasons why people wouldn't want to use their real or legal name. I'm not using my real or legal name in this context. Somehow all of my advocacy work has fallen under my sex worker name so that I can share information with my community faster to a larger audience. And that is something that is important to me. And I think also just being a woman online makes me want to use a name that's not my legal name. And I regret every time I've ever used my legal name anywhere on the internet.
So let me just tee on to that with a couple of thoughts. And going back to the politics of this whole thing, it's pretty clear that a lot of the internet companies thought that they could sort of sacrifice sex workers to preserve our firewall for their reforms to 230, right? Like that was part of the conversation. It was like, yeah, maybe this is bad, but this will be the end of it, right? And I think when we see things like the Earn It Act that go to attacking the ability to be anonymous online, right? That it turns out that Congress can go back and use sex trafficking again as a baseline again to pursue these broader sort of attacks on things like encryption. And by the way, they're going to start coming after things that both impact sex workers directly, but also impact some of the things that the platforms really care about, their heartland sort of concerns. So, right, like this is Facebook's real concern, right? They want to have a real name policy. Some other platforms don't, right? They want to offer anonymous speech as part of their overarching, sort of construction of a community. And they are going to find that their failure to show up for sex workers in FOSTA and SESTA, or the failure to go to the mat there, eventually the folks in Congress who really want to come after them are going to still come after them, right? Like they are going to have their turn. And we're starting to see that now with things like Earn It, right? And it's unfortunate, of course, that we put sex workers right in the middle of it again, but it's going to keep happening, right? And I think that's at the core of a lot of these proposals is like, who can we sort of scapegoat, or who can we put at the center of a moral panic to justify these really, big ticket swings at some of the things that the platforms are doing, whether that's copyright infringement for Hollywood, whether that's encryption for the law enforcement folks, whether that's political discrimination for folks who think that that they're being politically discriminated against, whether that's, you name it. So I think there's a way in which the politics of this will enable this pattern to sort of repeat itself.
And it seems like, I'm even thinking of the Devin Nunes cow suit, right? So proceeding anonymously online to engage in certain political speech, and Devin Nunes was not able to uncover the identity of that account, in part because of Section 230's protections. Twitter doesn't have much to worry about in terms of affirmative claims against it, so it really has no incentive to bring that user in particular to the table. When you bring in the sex workers into that, then the lack of that protection or liability protection to the platform really gets to the heart of removing that extra layer of protection that goes to safety and health outcomes and things like that. I think it would be interesting to talk a little bit about PACT and sort of the due process concerns, because actually it was interesting, Blunt, reading Erased and reading about the shadow banning, because I had actually never encountered that term in this, outside the context of like, I'm a conservative and I'm being shadow banned and they're downplaying my speech with the algorithm. Do you think that, and again, speaking only for yourself, would you welcome some transparency in moderation practices and some ability to go to a platform and say, hey, you said your policies were X, you've not been moderating me as such?
I mean, I don't trust the platforms. I also think that if you have a content moderation system that like mirrors the misogyny and transmisogyny and whorephobia of the creators of that platform, you don't have a content moderation system. You would just have another system of oppression and violence. I wouldn't trust the platforms to be transparent in those processes. And I actually have a lot of experience being deplatformed and sort of having back-end conversations with people who work on the platform, understanding the ways in which it's happened. We're actually right now, our next research project is on content moderation and shadow banning and deplatforming, and just like reading folks' experiences of losing access to their accounts, like paying money to get their accounts back. I don't think that transparency is possible. And I'm thinking right now about how so many of these major social media platforms have a set of terms of service for the consumer to use and a separate like internal term of service for content moderators to use, and then a different one that they send out to brands. So I'm thinking of the salty exposition of the Victoria's Secret's terms of service with which they had to follow, which like showed that like Kim Kardashian's photo was staying up because her hand was on her breast, but it wasn't leaving an indentation in her breast. So, right, like there's like a bunch of fat phobia behind those types of of rules and how they're practiced and policed. So I don't really think that, I guess more transparency might be good, but I don't trust that transparency to be accurate, or that they're saying the same things.
I also think, just to build on what Blunt said, like, I don't know, my kind of like current view on transparency is like, you know, I always think about the phrase like sunlight is the best disinfectant, and it's like, it's not. Disinfectant is the best disinfectant, right? Like, you know, like sunlight is actually not a particularly good disinfectant. And, you know, it's not that, so transparency and due process are different things. Due process does grant you sort of additional options in terms of like being able to sort of appeal decisions or sort of appeal the grounds. But you know, I don't know, now I'm thinking about like the recent Supreme Court cases where it's like, well, you know, they didn't follow the Administrative Procedure Act with regards to the DACA revocation. It's like, well, wait, hold on. I mean, yes, that's good, right? Like they should follow the rules, but also this is bad, right? Like I don't want them to be able to revoke DACA even if they follow the rules. So I think that, you know, one challenge of the due process approach, especially like, and transparency and due process both, is like, you know, how are, you know, and maybe it's just not Congress's role, like to sort of regulate these platforms. I do think that requiring platforms to follow the First Amendment would be like net bad for the world. But I worry that like all of this energy is going to kind of transparency and due process, and not enough of it is going to like, hey, how is the way that these platforms are enforcing their rules harming folks, especially marginalized folks, right? Like that's the question for me that's like the most important one to answer, is like, how can these platforms better serve and protect like the users that often are the ones who are like on the forefront of doing like meaningful, interesting work on the platforms, like sex workers, like Black women on Twitter, right? But B, also like, what does it look like to think about really, really deeply about like what like access to these platforms and what rules look like that are more connected to power, rather than to try to be like, to say like, as long as we're following the process, everything's fine.
Yeah, and I think
sorry, go ahead, Blunt.
I was just gonna comment quickly on the Earn It Act. When I think about the Earn It Act and how it's being passed under language to stop child sexual exploitative material, I think about FOSTA in the way that it chilled speech in such an overly broad way. And when I'm thinking of Earn It being potentially signed into law, I think about the way that speech about abortion, about minors accessing abortion, the ways that queer and trans youth access sex ed, how that would be chilled and self-censored, and that people who are trying to actually escape situations of sexual abuse wouldn't be able to find that information and might actually wind up in a situation where their platform, where their like account is deleted and they're totally like disconnected from the communities that keep them safe and that information that keeps them safe.
I completely agree. And I just want to underscore, I think it's important when you're thinking about all of these reform provisions, and, you know, PACT Act is bipartisan, but, you know, a lot of the elements are similar in some ways to what's in the executive order. And I think it's important to ask, who is this trying to empower? Right. And the answer, especially with the executive order, and I think maybe even with the PACT Act, is empowering critics of the platforms who would love nothing more than for the platforms to just admit that they discriminate against conservatives, right? It's a win either way, right? Either the platforms say, yes, indeed, we have a conservative bias, or they say, no, and we don't have a conservative bias, and we will bend over backwards to prove how unbiased we are against conservatives, right? And I think that's sort of the root of it. And what's not at the root of it is like, how do we empower sex workers? How do we empower victims of child abuse? How do we empower marginalized communities who are getting shadow banned or deplatformed, or are sort of on the fringes of some of these exceptions to 230 in a way that platforms act in an overcautious way that ends up disenfranchising them? I don't think any of these bills are designed to empower those communities. They're being developed without consultation with those communities. They're not aimed, as Kendra said, at the substance of what platforms can do with respect to those communities. And, you know, I share the pessimism all around about them.
Yeah, and I think that as we continue to have these conversations about 230, that we need to make sure that they're not just taking place from a legal perspective, that we like step outside that legal silo and continue to invite and to listen to and to center the communities who are most impacted by the upcoming carve-outs to 230.
Agree 100%. I mean, I think you can't develop legislation that's going to affect the entire internet without thinking about who the communities are that benefit from, rely upon, use the internet for everything they do. And these bills are not coming out of any kind of process, and the executive order not coming out of any kind of process that values that or seeks that input.
All right, well, I see we're at about an hour. I think that we had a little bit of an ambitious agenda here, but I think we got some really good work done. Are there any final words that any of you would like to say about any of this?
No, thank you for inviting me to have this conversation. I think a lot of the work that Hacking Hustling does is encouraging people with institutional power to invite communities who might not have that access into the spaces to have these conversations, so that we have the opportunity to speak for ourselves on behalf of our communities, rather than advocates just sharing traumatic stories to prove a point. I think it's really important that these words are coming from the people who are impacted by these decisions. So thank you so much for having me here.
Well, thank you for coming, and thank you for all the great work that you all are doing with Hacking Hustling and all the other great stuff you're doing. This will be posted online, and I will circulate a link we'll have when we have one, and I'll also post some of the materials that I've placed in the chat. Thank you so much for joining us, and have a good rest of the day.
Thanks, Andy.
All right,
Thanks, Andy. Thanks, Blunt.
you.
Thanks, Kendra.
Bye.
Have a good one, everyone.
You too, bye.